Good day, everyone. I am Dr. Daniel Matthew from National Law University, Delhi. And today we'll be discussing a crucial aspect of property law, that is, transfer by co-owners under Section 44 of the Transfer of Property Act. This provision addresses one of the most common scenarios in property ownership. What happens when one co-owner decides to transfer their share of jointly owned property? Now, try and imagine that you are living in a house that belongs to your family, and suddenly you discover that one of your relatives has sold their share to a complete stranger. What rights would this stranger have? Can they move it? Can they demand partition? These are the kind of questions that Section 44 attempts to answer. In an attempt to balance the rights of co-owners to transfer their property with the protection of family interest, particularly in cases involving dwelling houses. So by the end of this video, you will be able to understand the fundamental principle of transfer by co-owners under Section 44. You will also be able to analyze the rule of substitution and its application in co-ownership transfers. You will be able to examine the special provisions regarding dwelling houses belonging to undivided families. Your effort will also help you explore the rights and limitations of transferees in cases of co-owned property. This exploration will help you understand the concept of partition and its relationship with transfers by co-owners. Thus, in this video, we aim to explain the legal framework governing transfers by co-owners under Section 44. We also want to help differentiate between the rights of transferees in general property transfer versus in transfers of dwelling houses. You would also be able to evaluate the conditions and limitations affecting transferred shares in co-owned property. Your ability would also be enhanced when it comes to applying the principles of Section 44 to real-world scenarios involving co-ownership transfer. It will help you to analyze the legal remedies available to transferees of co-owned property. So with that background, let's delve into the topic. The law pertaining to transfer by co-owners is contained, as we mentioned, in Section 44 of the Transfer of Property Act. It provides that where one or two or more co-owners of immovable property legally competent in that behalf transfers his share of such property or any interest therein, the transfer or interest, and so far as necessary to give effect to the transfer, the joint transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of the transfer, the share or interest so transferred. Where the transferee of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. This is what we call a rule of substitution and operationalizes where there are more than one person as owner of the property and one such person sells his shares in the property. The transferee in such instances steps into the shoes of the transferor and he is entitled to all the rights that the transferee had in the property and would also be accountable for any liabilities that the transferor was accountable for. If we carefully see, the second part of Section 44 of the Transfer of Property Act protects the integrity of a family house and prevents the entry of strangers into the privacy of the family. Therefore, if the property is sold is a share of a dwelling house, then if the transferee is a stranger to the family, he can only seek partition and specification of his share, but cannot claim a right of joint residence that was previously available to the transferor. Therefore, in such situation, the rule of substitution would not apply and the right acquired by the transferee would only be limited to enforcing a partition. For example, if there are three brothers who jointly inherit a house and a land from their father in identical shares, one of the brother sells his share to A. Since A is a stranger to the family, he cannot claim a joint residence in the house. His remedy at best would be to seek a partition and demarcation of his share. But with respect to the land, he will step into the shoes of the transferor and will have the same rights and liabilities that the transferor had. In Geeta Devi versus Om Prakash, a 2001 decision of the Allahabad High Court, it was held that by the time the Act came to be enacted, the legislature had in view the aforesaid parent provision engrafted in Section 44 of the Transfer of Property Act, to the effect that a stranger to the family who becomes the transferee of an undivided share in one of the co-owners in the dwelling house belonging to the undivided family could not claim a right of joint possession or common or part enjoyment of the house with other co-owners of the dwelling house. Now, implicit in this provision was the legislative intent that a stranger should be kept away from common dwelling house occupied by other co-sharers. It was enacted with the avowed objective of ensuring peaceful enjoyment of a common dwelling house by the remaining co-owners being members of the same family sharing a same hearth or a home. The concept of transfer includes both an absolute transfer as well as transfer of an interest in immovable property. The rule specified herein applies therefore also to a mortgage, a lease sale, and also to involuntary sales, as such the rule of equity, justice, and good conscience. Similarly, purchaser of an undivided interest of the co-partner of Hindu joint family does not have a right to joint possession, and he can only, as we discussed before, sue for partition. Till the time partition does not happen, the purchaser cannot ask for exclusive possession of the property. Section 44 therefore is contingent on the idea that there is ownership with the transferor. To put it differently, if the transferor has no ownership in the property, Section 44 of the Transfer of Property Act has no application. Where the alleged co-sharer of the property neither has the title in the property nor any saleable right, a sale executed by such a person would be invalid and the transferee would not be entitled to possession or enjoyment of property so purchased by him. Now, joint owners cannot sell more than their share in the property. Any attempt to sell more than their share would be clearly invalid or illegal. Now, in Durga Prasad versus Special Secretary, Tourism Department, Government of Sikkim, it was held that Section 44 enacts the well-known principle of substitution. When one of the several co-owners transfers his share, the transferee then stands in the shoes of the transferor and thereby acquires a right to joint possession or part enjoyment of the property, including the right to enforce partition. This right is, however, subject to the conditions and liabilities affecting at the time of the transfer, the shares or interest so transferred. All co-owners of a property have a right to its joint possession, have the right for the enjoyment of which partition suit is not required. While every co-owner has the right to enjoy the property, such enjoyment cannot and should not interfere with the enjoyment of property by other users. Where a co-owner spends his money on the joint property at the time of partition, an allotment should be made that would enable him to, so far as possible, keep the advantages of the improvement. When one co-sharer enters into contract to transfer his undivided share in an unpartitioned property, such transfer contract can be enforced against such transferee co-sharer to the extent of his right and interest in the joint property. In Ananta Sahu versus Gopal Sahu, a 2021 decision of the Guwahati High Court, it was held that the undivided share in joint property before partition can be transferred by a co-sharer or more than one co-sharer, and the transferee acquires the same right and interest in the property transferred as of the transferor. The only exception is, as we discussed earlier, in the case of a dwelling house belonging to an undivided family. Such transferee, when not a member of the family or who is a stranger, cannot, as we discussed earlier, claim joint possession or common enjoyment of the dwelling house with other co-sharers, and the remedy only is to seek a partition. Another condition is that neither the co-sharer can transfer anything greater than his interest in the joint property, nor the transferee acquire any right or interest greater than what the transferor had in the joint property, or in other words, the transferee steps into the shoes of the transferor or co-sharer, and therefore, when a co-sharer entered into a contract to transfer his interest in the unpartitioned property, such contract can be enforced against such transferees or co-sharers to the extent of their rights and interest in the joint property. The transferee who acquires the right of the transferor cannot be disturbed by other co-owners. A co-owner not in actual physical possession or exclusive occupation cannot transfer a valid title to that portion, but the transferee is entitled to get a share out of the property to be allotted to the transferor at the time of partition, or get a decree of joint possession, or sue him for compensation. In Bhartu versus Rani Sarup, a 1981 decision, it was held that the rights of a transferee from a co-owner are not entirely dependent on judicial decisions, but are regulated by Section 44 of the Transfer of Property Act, which provides that where one or two or more co-owners of an immovable property legally competent in that behalf transfers their share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce partition of the same. But this, as we discussed earlier, is subject to conditions and liabilities affecting at the date of the transfer, the share or interest so transferred. According to this statutory provision also, what transferee gets is the right of the transferor to joint possession and to enforce a partition of the same, irrespective of the fact whether the property sold is fractional share or a specified portion exclusively in possession of the transferor. Again, it cannot be disputed that when a co-sharer is in exclusive possession of the specified portion of the joint holding, he is in possession thereof as a co-sharer, and all other co-sharers continue to be in constructive possession. By the transfer of that land by one co-sharer, can it be said that other co-sharers cease to be co-sharers in that land or to be in constructive possession? Similarly, in Om Prakash versus Chajju Ram, a decision of the Punjab and Haryana High Court in 1992, it was held that a co-sharer who is in exclusive possession cannot be permitted to raise construction on the land in his possession, as every other co-sharer is also a joint owner of every inch of the entire joint holding, till the same is regularly partitioned by metes and bounds. It is also important to remember that the transferee is not entitled to joint possession where he has purchased an undivided interest of the co-partner, even where the co-partner is permitted to alienate it. The transferee is only entitled to enforce partition of the share that he has acquired subject to any changes or encumbrances affecting the co-partnery property or interest at the time of the transfer. The right to enforce partition is available to all co-owners, even in case of a dwelling house. While for enforcing a partition, there must be unity of possession, title, and community of interest, the co-owner cannot claim a specific piece of the property as coming to his share. and the property would be partitioned generally. For example, there are three co-partners collectively owning a house and four pieces of land A, B, C, D. One of the co-partner X sells to D a land whose value is to the extent of one third of the total property to the purchaser. Since the entire interest is undivided in a suit for partition and handing over of the share to the purchaser, he cannot insist on obtaining only the land D, as which property would go to which co-partner can only be ascertained only after the partition has been effected. Since co-owners are entitled to transfer their respective shares under the Transfer of Property Act, they must seek partition first. In Ramdas vs. Sitabai, a 2009 decision by the Supreme Court, it was held that in the case of a purchase of an undivided share of co-sharer by a third party, possession can be handed over by partition amicably through mutual settlement by metes and bounds or by a decree of the court. Without there being any physical formal partition of an undivided landed property, a co-sharer cannot put a vendee in possession, although such a co-sharer may have the right to transfer his undivided share. In Siddheshwar Mukherjee versus Bhuvneshwar Prasad Narayan Singh, the Supreme Court in 1953 had held that all that vendee purchased at the execution sale was the undivided interest of co-partner in the joint property. He did not acquire title to any defined share in the property and was not entitled to joint possession from the date of his purchase. He could work out his rights only by a suit for partition, and his rights to possession would date from the period when a specific allotment was made in his favor. Similarly, in M.V.S. Rao versus M. Narasimha Swamy, a Supreme Court decision of 1966, it was held that it is a well settled law that the purchaser of co-partner's undivided interest in joint family property is not entitled to possession of what he has purchased. His only right is to sue for partition of the property and ask for allotment to him of that which on partition might be found to fall in the share of the co-partner whose share he has purchased. The rule of partition is available even in case of lease, including a monthly lease or a lease liable to forfeiture in case of certain contingencies, except when it causes inconvenience to the rest of the family members. In case of a usufructory mortgage, where the possession is with a mortgage, it is the mortgage and not the mortgager who has a right to enforce partition and to claim possession. A purchaser of a share is not liable to the damage caused to the property after the transfer by the transferor. The provision also incorporates an exception to the general rule of the transferor stepping into the shoes of the transferee, but only where the property purchased is a share in a dwelling house. In such instances, the right of transferee would be to ask for partition only and not a right of joint residence with other members. For the application of the exception, it is necessary to show that the property is a dwelling house belonging to the family. Purchaser of the share is not a member of the family but can be described as a stranger in terms of the relation to the family members, and they have not let out the dwelling house completely or abandoned it. As indicated earlier, the rule is incorporated in the Act to prevent the entry of strangers into the privacy of a dwelling house. The dwelling house includes structures or the building and also adjacent buildings, curtilage, courtyard, garden, orchard, and everything that is for the convenient occupation of the house. But the mere fact of the undivided character of any house due to the nature of construction and the land underneath would not make it undivided for the application of this rule. The applicability of this proviso for the specific performance of agreement of sale of house would not be applicable where the vendor's wife had half share in undivided property. Thus, for a stranger the only remedy is to ask for partition, as he cannot claim a right of joint resident being a stranger to the family in a property that is residential house of an undivided family. A transferee who is a stranger to the dwelling house cannot force his way into the dwelling house and to obtain order from the court or make a settlement with co-owners who have not transferred their shares to him. It is immaterial how many members are there in the family or what is the character of the family. It is an undivided family or even a nuclear family. It is also not required that the family had continuously lived in the house or permanently or even temporarily unless they have abandoned all idea of occupying it as a house or have let it out completely. Therefore, it is important to note that a partial letting at the instance of a stranger who owns a portion of the undivided house would not alter the character. But if he occupies it after effecting a partition of the house, then the situation would be completely different. In all other cases, the only remedy available to him would be to seek partition, and he shall not be entitled to joint possession or other common or part enjoyment of the house, but is entitled only to partition of the house. This is the key idea under Section 44 of the Transfer of Property Act. Thus, it should be clearly understood that the second para of the Section 44 of the Transfer of Property Act is applicable only in case the property in question is a dwelling house and not otherwise. In B. Sau versus B. Dasadadikari, a 2019 Calcutta High Court decision, it was held that existence of a dwelling house belonging to the undivided family of the plaintiffs is a sine qua non to attract the second paragraph of Section 44 of the Transfer of Property Act. In Hafizullah Sheikh versus Puranchand Jain, a 2017 decision of the Madhya Pradesh High Court, it was held that mere non-filing of the partition suit would extinguish his rights in the property, as the house was not in use for residential purpose, rather it was being used for commercial purpose. Hence, it would not be a dwelling house, and therefore suit of partition would not be necessary. In a right of exercise of preemption suit against the stranger purchaser, where a stranger purchaser was put in possession of his vendor's house since purchase, the other co-sharers of the shared dwelling house complex has a right to resist the possession under Section 44 of the Transfer of Property Act. However, the co-sharers cannot exercise their right to preemption in the absence of a claim of partition by the stranger purchaser. In Gautam Paul versus Devi Rani Paul, a 2001 decision of the Supreme Court, it was held that there is no law which provides that co-sharers must only sell his or her share to another co-sharer. The strangers or outsiders can purchase shares even in a dwelling house. Section 44 of the Transfer of Property Act provides that transferee of a share of a dwelling house, if he or she is not a member of the family, gets no right of joint possession or common enjoyment. Section 44 therefore adequately protects the family members from intrusion by an outsider into the dwelling house. The only manner, as we've discussed twice before, in which an outsider can get possession is to sue for possession and claim separation of his share. In that case, Section 4 of the Partition Act comes into play. Except for Section 4 of the Partition Act, there is no other law which provides a right to co-sharer to purchase the shares sold to an outsider. Thus, before the right of preemption under Section 4 is exercised, the conditions laid down therein have to be complied with. One of the conditions is that the outsider must sue for partition. Section 4 does not provide the co-sharer a right to preempt where the stranger or outsider does nothing after purchasing the share. Similarly, in Bulu Sarkhel versus Kali Prasad, the 2012 decision of the Calcutta High Court, it was held that before invoking the right of preemption of a co-sharer against a stranger of a dwelling house under Section 4 of the Partition Act, it has to be shown that the stranger purchaser made initiation of proceedings or claim partition at whatever stage, including the stage of execution of a decree of partition. A mere assertion of a claim to a share without demanding separation and possession by the outsider is not enough to give other co-shares a right of preemption. As we conclude today's lecture on transfer by co-owners, please remember that Section 44 represents a careful balance between individuals' property rights and family interest. The provision recognizes a co-owner's right to transfer their share while protecting the integrity of family dwelling houses through specific restrictions on transferees who are strangers to the family. The key takeaway is that while a co-owner has the freedom to transfer their share, the rights of the transferee vary depending on the nature of the property and their relationship to the family. In the case of dwelling houses, the law prioritizes family privacy over absolute transfer rights, requiring strangers to seek partition rather than claim immediate joint possession. In your future practice, you will frequently encounter cases involving co-ownership transfers. Understanding these principles, therefore, will be crucial in advising your clients and resolving disputes effectively. I thank you again for your attention and for watching this program. Thank you.